Yes, Mr. Hogan.
I'm obliged, my lord. Just before lunch, we were looking at Rule 36.22.
Yeah.
And my lord asked me to deal with the point raised by Mr. Hull and the significance of 36.221D. In order to do so, can I expand the point a little, just to give the court a little more colour as to how the scheme of recoverable benefits works? If you have the authorities bundle, Section 6 of the 1997 Act, which should be at page 17.
One seven.
The statute imposes...
My fault. Wrong file. Page 17 of the authorities file, which is what did you say again?
Section 6 of the 1997 Act.
Yeah.
That imposes an obligation on a compensating party to pay to the Secretary of State an amount equal to the total amount of the recoverable benefit, and that's the recoverable amount. The deductible amount is something different. What the 1997 Act provides for is a scheme by which, if you go to trial on a case and the judge makes findings and awards for loss of earnings, cost of care, that sort of thing, under the Act, the benefits must be hypothecated against particular heads of loss. And that is illustrated by Schedule 2, which is at page 38 in that bundle. And you'll see there that there's a head of compensation in column 1 and then a defined list of benefits in column 2. Yeah. And that continues over the page, dealing with, if you like, heads of loss set against various types of benefits. And although you don't have it in the bundle, there is a section 15 of the 1997 Act which imposes a duty on a trial judge, when he makes an award of damages, to use this table to deduct from the heads of loss the relevant heads of damage. But
what's the statutory reference to that?
Section 15. I do apologise.
Yes, I do.
Doesn't seem to be in the bundle.
Sorry, you meant deduct relevant. Sorry, I think you used maybe the wrong word. Can you say it again?
Yes. You deduct from the particular head of loss whatever relevant benefits have been paid if they fall within the box in column 2.
Yes. Okay.
And so the balance is then payable to the claimant as damages as part of it.
It's actually you deduct from the relevant head of compensation.
Yes.
The benefits.
Yes.
Yeah.
Yes. So in effect, the defendant tortfeasor doesn't pay twice to the Secretary of State and to the claimant.
So the trial judge makes those deductions.
He does.
Against a particular head of loss, he has information that a certain amount had been paid under one of these types of head of compensation, as it's called. Yeah. Job seekers, no, it wouldn't be that, would it? In an ordinary case, incapacity benefit.
Yes.
So he would have the information that would allow him to make deductions from the sum to be awarded to the claimant for the benefits received.
Exactly.
Yeah.
And that is no more nor less than the certificate of benefits which has been paid, which is conclusive proof for these purposes of what has been paid by way of deductible benefits. That's clear then how it works if it goes to trial. But of course most trade cases don't go to trial, so then one has to look at Rule 36.22 to see what this is talking about. And the actual starting point would be 36.223 on page 1313, which gives the defendant a choice. The choice that a defendant has who makes a Part 36 offer is that they can state when they make that offer that it's made without regard to any liability for recoverable amounts, or that it is intended to include any deductible amounts. And to give the court an example of how that works, a defendant could make an offer of £400,000 without regard to any liability for recoverable amounts, and then it will pay the 400 to the claimant, and then any benefits to the Secretary of State. Conversely, the defendant could make an offer of 400, including deductible amounts, and so the 400 includes whatever benefits need to go off to the Secretary of State if the case is settled. And the court will appreciate our case falls within the second of those alternatives. But the reason that it matters is because if you go to 36.228, this deals with the circumstances of what counts for success if a case goes to trial, and whether the claimant has beaten a defendant's offer or not. And what the effect of 36.228 is that when looking at success for the purposes of whether you've beaten the Part 36 or not, you're taking into account the deductible, you're taking into account the net amount after deductions have been made. So the significance of the reference to 36.221D, deductible amount, talking about damages, is it's predicated primarily on what happens at trial and working out whether you've beaten a defendant's Part 36 offer or not. Now, it therefore follows...
Hang on.
Forgive me. It therefore follows that the use of the phrase deductible amounts has a dual purpose in section rule 36.22, because you'll see at 36.228 there's a cross reference there to section 15 of the 1997 Act. That's the exercise the judge does at trial. The actual reference in 36.22D1 is to section 8 rather than section 15.
Sorry, where are you getting those two references?
Oh, I'm sorry. It's page 1314.
Yeah.
If you look at sub
Oh, sorry, the bit in brackets.
That's the one.
I hadn't read on down. Right. So there's references there to section 15.
Yes.
And that is what?
That is the statute imposing a duty on the judge to reduce heads of loss by the deductible benefits.
Yeah, so that's the one you told us about before.
Yeah. And then if you go back to 36.221D, where it's talking about deductible amount.
36.22.
1D, little Roman 1, deductible amount.
Yeah.
That refers to section 8 rather than section 15, but it's the same concept of deducting deductible amounts, and so there's no significance to the use of the word damages, because the definition of deductible amount has to be used at trial. Therefore, it would be adding yet another layer of technicality or sophistication to talk about deductible amounts which don't apply at trial. And there's no more significance to it than that. And the point that I would conclude with that is it would be a quantum leap to say that this is meant to cross-reference in any way to 44.14. It's dealing with a completely different purpose.
Okay.
So, my lords, those are all the points I wanted to make on Part 36. Can I now turn to Cartwright and Adelekan? I am very conscious of the diffidence with which I should approach making submissions on what is ratio and what is obiter to the Court of Appeal. But of course, in this case, there is a stark line between Mr. Hutton and myself as to which paragraphs of Cartwright and which paragraphs of Adelekan are to be regarded as ratio or obiter. In my submission, however, there are two particular points of significance which I want to put before the court. The first one relates to Cartwright. And in my submission, a necessary part of the ratio of any decision is the principle of law upon which the decision is based. And a principle of law may be relatively narrow in terms of its significance, or it may be a wider principle of law which is of greater significance. But in the Cartwright case, this court was dealing with a very narrow point indeed, which is what 44.14 means. And, my lords, you've already been taken to the relevant paragraphs by Mr. Hutton, where the court, on the face of it, was clear that 44.14 doesn't apply to settlements at all. And testing that suggestion, it cannot be the case that the ratio of a case hinges very narrowly upon what the particular facts were. A case can be settled by numerous means: a Tomlin order, a consent order, a Part 36 settlement, or even by exchange of correspondence. And in my submission, the suggestion that you need 4 or 5 cases in the Court of Appeal to establish the particular principles of significance of that is simply wrong. The issue of what does 44.14 mean was at the heart of the decision in Cartwright and forms part of its ratio. The second point, however, which is of significance, is this: when a court gives a decision, no judge sitting at first instance or on appeal says, I'm giving 10 reasons for my judgment, and reasons 1, 2 and 3 are the ratio. Reasons 4 to 10 are obiter. The ratio of a case is always decided by the subsequent court when considering and applying the case law as part of the common law doctrine of precedent. And in this case, you have a subsequent decision of the Supreme Court in Adelekan, where one of the issues, in order to determine the starting point for the decision in Adelekan, is what does Cartwright mean? And you have been taken to the 3 particular paragraphs, 7, 14 and 31 of Lord Briggs's judgment, where he is extremely clear that his interpretation of the decision of Cartwright is that it draws a bright line between cases which settle and cases which do not. Now, if the court accepts that is a true reading of Cartwright and the effect of Adelekan interpreting Cartwright, in a sense that is the end of this appeal, because this court, as it has already been noted, is bound to apply the ratio in those 2 decisions. So that's what I wanted to say about the 2 principal authorities. And I would now wish to put forward the alternative submission, if I'm wrong about that, and the court is effectively approaching the interpretation or construction of these rules afresh. May I begin by pointing out that orders for damages and interest are logically going to be made.
So, logically, you think Lord Justice Lewison was wrong when he gave permission to appeal?
What I can say is Lord Justice Lewison didn't have the benefit of full argument, or indeed any oral argument on the point. So, turning to the point of statutory interpretation, as I say, an order under 44.14 must logically arise at the conclusion of a case. And therefore, a settlement also arising necessarily at the conclusion of a case means that for the practical purposes, that is the end of the case prior to any issue of enforcement. But the court has already noted that in respect of Part 36 settlements generally, there must be an intervening step where if a Part 36 settlement isn't paid, then the claimant applies to court for a judgment which it can enforce. So on that starting point, nobody has had to apply for enforcement in this case. The settlement was, I understand, promptly paid within a reasonable period. And so there was no necessity for my client to apply for judgment to enforce a settlement. But the observations on Rule 44.14 that I put before the court are this. As the court has already noted and canvassed in the Cartwright judgment, it could have been possible to put forward very wide words at that time in Rule 44.14, so that in any circumstances in which a claimant recovers something by some means in litigation, set off or bind, but the words are narrow, deliberately narrow in my submission. Secondly, the effect of the limiting words in practice is readily discernible. Only a tiny proportion of cases will conclude at trial, where 44.14 would obviously apply. Conversely, Part 36 settlements, Tomlin orders, settlements by correspondence will constitute the vast majority of disposals. And so, in effect, the wording of the rule dictates it's taking itself out of the normal way that the case concludes. And returning to a point echoed or foreshadowed in Cartwright, no guidance, no elaboration, no practice direction, 44.14 exists in a small box of the civil procedure rules on its own. So when one then looks at that on one hand, and then contrasts the position with the order made in this case, under 36.229, the issue before Judge Sephton was binary. Should the claimant have permission, yes or no? And then secondly, should he adjust the Part 36 offer or direct that be done? But that's what he's doing. He's not ordering or finding or giving judgment for any particular sum. He's simply moving the Part 36 offer from the side of net payment slightly further across to the side of deductible benefits. They're both constituent elements of one single Part 36 offer. The obligation to make payment arises from the rules, not the order. And if one considers the counterfactual proposition as to what would have happened if Judge Sephton had refused permission, then the case would have gone to trial, and the court would then have made an order for damages and interest.
So when you say the obligation to pay arises from the rules, does the obligation to pay not arise from a contract? It's an offer and acceptance. Admittedly, it's one which is only done with the permission of the court. But why isn't it just you said the obligation to pay arises from the rules? I mean,
Yeah.
The obligation to pay arises from contract, albeit that it can be enforced in accordance with the rules.
I would put forward the suggestion that Part 36 doesn't exactly equate with a contract because its origins are statutory rather than the common law. And similarly, Part 36 modifies certain contractual principles, most obviously offer and acceptance. You'll see seen in the rules that you can accept at any time, even if you've written in correspondence that you've rejected their offer. You can change your mind the following day and the offer remains live. But what Part 36 and that rule I took you to about you've got to pay in 14 days, and if you don't, judgment follows. That, in a sense, is the statutory embodiment of the Tomlin order jurisdiction, namely that you have the agreement contained in the schedule, and then if that's broken, you don't have to start a second set of proceedings, you just apply to enforce. And that's the parallel to that provision. So if one looked at it in a contractual light, one would say that part and parcel of the bundle of contractual terms was that this is the offer, this is the acceptance, and part of the terms are that you will pay in 14 days, implied by law, contained within the relevant rule, Part 36.
Speaking for myself, I think I'm finding this too complicated. Albeit there's still special provisions made about the regime. If you just take a simple case which is accepted within 21 days, you've got an offer in terms expressed as an offer. You've got an acceptance expressed in terms of an acceptance. If it's accepted within that time, then it gives rise to an obligation to pay the offer sum. Yes. You don't need an implied term of about 14 days because you've got a provision of the rule which says if you haven't discharged that obligation within 14 days, you can ask for judgment and you can go down that route. There's nothing, although I accept that there are some bits floating around the edges, the essence of my Lord's question is correct, isn't it? It's a contractual obligation which comes into existence when the offer is accepted. Full stop.
Yes.
So why do we need to start talking about, or why did you cavil, if I can, I don't mean that tendentiously, but why did you cavil with my Lord when he said, well, this is a contractual obligation?
It comes from the wording of the very first part of Part 36, which is at 36.1, page 1280.
Can you give me the page again?
1280.
Thank you.
I suppose 1281, the note in the White Book referring to Flynn and Scougal, appears to suggest that there is some view that their offers are not contractual in nature but are wholly procedural and subject to the rules of the court. Albeit that it then interestingly goes on to say that contractual principles come into play when construing the terms of the offer. So it's a form of, it might be regarded as a form of contract subject to a procedural code. Anyway, it may not matter, but because you just say whatever else it is and how we might dance on the head of a pin about that, it's not pursuant to a court order.
Exactly so, my Lord. And coming back to what my Lord Justice Stuart-Smith said, the simplest point is the fact that there's the 14-day obligation in the rules. So, in summary, what I would say on this point is it is actually a short point of statutory construction, indeed. The reality of the matter is, however you construe Judge Sephton's order, it's effectively giving effect ancillary to a settlement, supporting the settlement, the offer, and the acceptance agreed between the parties. Now, can I deal with two particular points which Mr. Hutton has reserved to his reply to my submissions, which are, first of all, the rule against absurdity, and the second is the Human Rights Act point. And if the court has my skeleton argument to hand, and in particular paragraph 103, which should be page 145 in the core bundle, that the court may have it separate.
Page which again?
It's page 145 in the core bundle.
145.
Paragraph 103 of the skeleton. What you will see there is I've identified, if you like, the other exceptions that Mr. Hutton would suggest support his case. And in particular terms, they are 5 in number. The first one is our case, where a claimant is disabled and qualifies for continuing receipt of social security benefits, so has to come to court to get permission if there's been an accrual of further benefits. Secondly, you have a claimant who lacks mental capacity, so there must be a court approval. Mr. Hutton would say that such a claimant is also subject to his exception to QOCS, because an order must be made. The third one is where you have a child who lacks legal capacity, and the settlement must be approved by the court, so there's an order. The next one is where you have a severely disabled claimant who gets provisional damages because they've got a brain injury, for example, with possible epilepsy, or periodic payments because they're paraplegic and need continuing care. Or where you have a situation where a dependent of a deceased, in essence a widow or an orphan, who also has to have an apportionment of the damages made, and he would say inflicted. And all of those instances, Mr. Hutton says, have been singled out as part of the legislative intention that they lose the protection that QOCS would otherwise give them. And there is no reason suggested in the defendant's 50 pages of skeleton arguments as to why, as part of a rational and proportionate procedural scheme, the legislative intention was to remove or reduce QOCS protection.
Would this be a fair categorisation of his five subcategories, that the more in need of protection you are, the more likely you are to have your damages reduced by the operation of the...
My Lord, I think that's the conclusion that must follow, if Mr. Hutton were right. But the court will be aware that when construing any statute, there is a presumption against absurdity. And you have in the bundle of documents, the bundle of authorities, at page 319, an excerpt from Benyon.
This is in the first or second?
It should be the first bundle, my lord.
319.
You'll see the summary there. 13.1, subparagraph 1. Court seeks to avoid a construction that produces an absurd result, since this is unlikely to have been intended by the legislator. Here the courts give a very wide meaning to the concept of absurdity, using it to include virtually any result which is impossible, unworkable, impracticable, inconvenient, anomalous, or illogical, futile, pointless, artificial, or productive of a disproportionate counter-mischief. The strength of the presumption depends on the degree to which there's an unreasonable result, but ultimately, of course, the presumption may be displaced if the legislative intention, as discerned from whatever other relevant factors there are, would indicate that that would be the appropriate necessary course to do. But of course, if the court accepts my construction of Rule 44.14, no such absurdity arises. In particular, everybody, like cases, are treated alike. All claimants are treated equally. And so in my submission, there's no need for the court to go down Mr. Hutton's route if you accept the construction I urge upon you. The very final area that I wish to address in submission is the Section 3 interpretive point. And can I say at the outset, Mr. Hutton raises an objection to my raising it, saying it's not a point that was run before the judge below. And he's absolutely right about that. The point wasn't raised before the judge below, because Judge Sephton felt he was bound by the case law, and the argument was relatively brief. But the circumstances in which the Court of Appeal, or indeed any appellate court, will enable a pure point of law to be raised by argument were canvassed in the judgment of Lord Justice Haddon Cave in a case called Singh and Das, which is in your bundle. And I suspect this court will have encountered this point before. If you have the first volume of the bundle of authority...
Well, I think I also was party to a decision which Notting Hill Finance and Shake, I mean, you basically say if it's a point of law that wouldn't have caused the trial below to take a different course, it's at one end of a spectrum of possibility in which you are likely to be able to run it on appeal because it's a pure point of law. It has no particular adverse consequences that can't be addressed in costs.
Right.
But if you were to be trying to run a point which might have caused the trial to go differently below, which you can't redo, you probably won't get permission to do it again because it can't be addressed in cost. I mean, that's a summary, isn't it?
My lord, that was the principle I was going to put before the court, and I won't develop it. But the point is actually a very short one. The first and starting point is that when you consider my client's settlement, that is her money, it is her property, it is in my submission a possession within Article 1 of the first protocol of the European Convention. The second point is that a QOCS scheme, the QOCS scheme, is an interference by the state with her possession. Sometimes it will benefit her, sometimes it might not benefit her, but at this stage it's just an interference with it. And thirdly, the state has a very wide margin of appreciation as to how it interferes with someone's possession. That is trite case law from the European Court. But what can't be done is if the interference is undertaken or has the effect of discrimination. So, in circumstances where the court has just been taken to paragraph 103 of my skeleton argument, all of the instances where those orders are made because of people's status, because they're young, because they're disabled, because they were married to someone, because they're the father or child of someone, or because they're disabled, as in this case. And Article 14, read with Article 1 of the first protocol, provides that you cannot put in place a statutory scheme, an interference with someone's right under the first protocol, which is put forward on what are discriminatory grounds. The effect, as the House of Lords has set out in the two cases of Regina and A, and also guiding Mendoza, is that the court must construe legislation, whether it's primary or secondary legislation, to give effect to the parties' human rights, including their Article 1 rights with their Article 14 rights. And so against that backdrop, the consequence of Mr. Hutton's position, ultimately, is not only that it would lead to an absurdity, but that it would lead to discrimination in the way that it affects disproportionately those vulnerable categories of claimants that have been identified in my skeleton argument. So for all those reasons, the points put forward by Mr. Hutton in my suggestion were founded. Now, those actually were all the points that I wanted to make to this court. The appeal is, of course, being dealt with on the basis of the current iteration of the QOCS regime.
Yeah.
It may be that the QOCS regime changes next year to a greater or lesser degree. But in reality, when this appeal was given permission by Lord Justice Lewis, it was not known at that time there would be a consultation, there would be moves to address the QOCS. And so this case is something of an oddity, but it simply has to be determined on the basis of the law as it is, not as the law as it may become. Those are the points I wanted. I'm conscious the panel may have questions for me.
What would you say in the context of the submissions you've made about A1P1 and so on, Mr. Hutton's underlying policy submission is to say, well, the rules are clear as to a claimant being penalised in costs for late acceptance of an offer. So that therefore, at root, what he's seeking is not unfair.
I think the position is this. Fairness needs to be looked at in two ways. Mr. Hutton has a good point that fairness would normally mean that claimants pay costs when they take a Part 36 offer late. Where Mr. Hutton's argument runs into difficulty is it's not every claimant. It's a limited number of people identified by the fact they need to come to court to get an order by reason of their status. And so the position is that if my client had not had to claim benefits and had simply accepted the Part 36 offer late, 2 years late, this argument wouldn't have arisen. But because she is in receipt of disability-related benefits, this argument does arise on Mr. Hutton's analysis and interpretation of the rules. But that consequence is avoided and parity is restored if the court adopts Section 3 centred approach, so that in effect people are treated alike.
So you say your interpretation means that people would be treated alike?
They would, because in effect, if the categories of claimant at my paragraph 103 are stripped out of the equation, they are in the same position as a claimant who is not disabled, who is of majority, who doesn't have a mental incapacity, and so on and so forth, in that they have the same level of QOCS protection across the board.
Depending on whether or not the case goes to trial or settles.
If the case goes to trial, then the Order 44.14 will bite.
Yeah.
On settlement, which is the instant point, if you accept my construction, then they're treated alike. If you accept Mr. Hutton's construction, then this small series of categories are worse off for no discernible, obvious reason.
Well, they're not that small, are they?
Well, they're 5 in number. That
Oh, see, you meant in terms of big, but I mean in terms of volume. When my lords and I were High Court judges, we would often be approving settlements. They're not that sort of small number of cases. Particularly.
Your better point is that they are all people who are in greater need of protection rather than lesser need of protection.
My lord's absolutely right. It's just counterintuitive that Parliament intended they should have less protection.
I understand, I think, all of them except for C, where the child is a client, where the claimant is a child and lacks legal capacity, a settlement must be approved by the court. What does the court actually do in those cases? Does it just simply say the settlement is approved?
Yep.
Because if it does say the settlement is approved, there is I think a distinction on any view to be drawn between a case where, as it were, we just have paragraph 1 of Judge Sephton's order and a paragraph 2. Whereas some of the other cases, as I understand it, require the court to deal with not just saying yay or nay to the settlement, but actually dealing with some monetary amounts. Is that right?
I noticed my Lord Justice Stuart-Smith was going to raise a point.
But from recollection, when you have an infant settlement, what you're actually doing is approving the settlement. But it is routine, in my recollection, to say in an order the settlement is approved in the terms that are then set out. Which may not be a complete answer to what you're saying.
It reflects common practice because obviously infant settlements run from minor injuries of a couple of £1,000 through to birth injuries.
Monsters.
There will usually be an order which will specify a sum, which on Mr. Hutton's argument is an order for damages and interest. The order may also go on to deal with what happens to the settlement, directions and so on. The money. What happens to the money? So there is a court order, but of course, if you were 19 years old, you would not need a court order at all to take a settlement.
Okay. Can I ask this? Has an A1P1 argument or a discrimination argument arisen before in any of the cases dealing with the Jackson cost reforms? I'd say I can't think of any, but your combined knowledge would be greater than mine.
There were certainly human rights arguments under the old Access to Justice Act scheme.
Yeah, yes.
The closest point I could find is a case called Kachia and Faluyi, which is in the second volume of Bundle of Authorities at page 411.
4-1 what?
At page 411 in volume 2.
Thank you.
It's not an.
So this is post-Jackson, but sorry,
no,
pre-Jackson, but post-Wolf.
Yes, and it's not A1P1, it's Article 6.
Okay.
But the facts of the case with this, there's a quirk in the Fatal Accidents Act that you can only bring one action. And if you don't scoop up within that one action every dependent, then you're in problems because you can't bring another action against the defendant. In Kachia and Faluyi, the question was, does bringing an action mean issuing the claim form, or does it mean service of the claim form? And the Court of Appeal accepted the argument that to give a human rights compliant construction to the Fatal Accidents Act, it had to mean served process, with the result that although a claim form had been issued but never served, no action had been brought.
Well, that looks pragmatic anyway.
I was going to say, if ever there was a case which on the merits was demanding of a particular answer. Why do I think there was a Scottish challenge? It probably wasn't to do with Jackson. A Scottish challenge, and I'm sort of thinking it's in an insurance context, where the question whether proceeds were or part of a settlement. I'm probably quite wrong. I've just got a sort of niggle. It was. It might even have been a credit hire case. I think I've tried to expunge it from my memory because it was so horrible. If it comes to me, and if it's even peripherally relevant, which are two very big ifs, I'll let people know, and you won't be disadvantaged by my inability to remember what I'm trying to think of.
Thank you, Michael.
Thank you very much, Mr. Hogan. Yes, Mr. Manley.
My Lord, thank you. My Lord, just on that last point, and it may not assist at all, the only other case that springs to my mind, there was a QOCS case to do with mixed claims called Brown and the Commissioner of the Metropolis, which came before this court, I think about 3 years ago. And from memory, I'm aware that the Equalities and Human Rights Commission was given permission to intervene in that case. I wasn't in that case, and I can't recall the precise scope of the argument, but that's the only other case that I can think of where a human rights issue may have arisen, but I can't recall the scope of the issue.
Okay. All right. Well, that's very helpful. Thank you.
What did you say it was called?
Brown and Commissioner of the Metropolis. And I think it was about 2019, but again, my memory may be failing at this point in the day.
And that wasn't mine.
I don't believe it was.
I have no recollection of the case I did last month. So 3 years ago is
Again,
absolutely no chance.
Not having been in front of the panel, the identity of the panel doesn't immediately spring to mind.
Okay, all right. Well,
It was Lord Justice McCone, David Richards, and Lord Justice Coulson.
well, that's why I said I've got no chance. Who did the judgment?
It was Lord Justice Coulson.
Yeah.
Well, my Lord, apologies if it's a wild goose
No,
chase.
absolutely.
It may not be relevant at all.
That's fine. If it was one of mine, I will. My lords don't need to worry. I will look it up, and if I think it's of any relevance, I will. I'll let you know. But that's useful. I got my disclaimer in early. It rang the vaguest of bells, but no more than that. Okay. Yeah.
My Lord, thank you. And April is very grateful for these few moments to address the court. Of course, April's concern is not the facts or outcome of this particular case, no disrespect to Miss Harrison or the defendant, but the potential wider implications, both in relation to the correct construction of CPR 36229, the narrow rule involved, but also those other categories of cases which fall in Mr. Hutton's basket if his argument of principle is correct. Lord, we're very
By that
grateful.
you mean effectively those summarised in Mr. Hogan's paragraph 103.
Indeed, so, my
talking
Lord,
about.
yes.
Yeah.
My Lord, we're very grateful to Lord Justice Coulson for the clarification in relation to paragraph 37 of the October minutes from the CPRC. I suspect that what's described as the small drafting rule amendment, perhaps a mastery of understatement, which proposes including agreements to pay damages within the new QOCS rules, has so far escaped the attention of personal injury practitioners in general in terms of its implications. But even if that is the rule that is proposed, and even if that is the intention to bring all agreements to pay damages within the scope of CPR 4414, that doesn't remove April's concerns in relation to this present case.
That doesn't what, sorry?
It doesn't remove April's concerns in relation to this present case. And that's for a number of short reasons. Firstly, of course, we don't know whether the proposed rule amendment is what will finally be adopted. If it is, we don't know when it will be adopted or what, if any, form of transitional provisions may accompany it. There are many cases which have already settled, which have the potential to be affected by the decision in this case. But equally for those members of April, there are many more cases which may settle before any new rule comes into being. And solicitors and counsel need to be able to advise their clients, particularly the sort of clients that are covered by the identified categories in paragraph 103 of Mr. Hogan's Scarton argument. Because as we've seen, if Mr. Hutton is correct, the effect of his argument, which underpins his narrow point in this case, is that it is not just late accepting claimants who are on benefits who may be affected by this decision, but it is all claimants who may seek periodical payments and wish to settle their case, whether in time or out of time. It is all claimants who seek provisional damages and wish to settle their case. All claimants where there may be an apportionment under the Fatal Accident Act, and potentially subject to the point raised by my Lord Justice Snowden, all protected party and child personal injury claimants. And in that regard, Lord, and it is not a decision on any point of principle, but we have included in the authorities bundle a decision in a case that was before Master MacLeod, a case by the name of MRA. And it's a first instance decision. And the reason it's included, my Lords, is because it identifies the sort of scope of argument that is out there at the moment, which has the potential to be resolved by the decision in this case, if this case addresses the wider points. But if not, it is likely to find itself coming before the first instance judges and then in due course this court. And the MRA case was a case involving a protected party and late acceptance of a Part 36 offer. And the main point in the case...
Can we look at it? Of
course, my Lord. It's in the authorities bundle, and it starts at page... it starts at page 229. And there's a helpful plain language summary by Master MacLeod on the very first page. So the main point concerned whether the claimant should be required to pay costs following a late acceptance.
Right.
And therefore the issues of injustice. But your Lordship will see at the bottom of that page reference to Cartwright. If I can just invite you to come on within that judgment to paragraph 65, which is on page 251. Because this goes to the point that was raised by my Lord Justice Snowden. Because the claimant was ordered to pay the costs after the expiry of the relevant period, and then there was an argument which was mooted but not decided in relation to the question of set-off and QOCS. And if we turn to paragraph 65, that point is referred to in the first sentence, that the judge was not going to decide the part argument which was mooted at the outset of both days of the hearing, that there were differences in treatments of protected parties versus non-protected parties, which rendered them more exposed to the situation here under QOCS. Lord, I'm not going to read it all out, but the short point in paragraph 65 is that there was discussion before the judge as to the form of order in such a case. So the two tasks the judge was dealing with was approval of the settlement and the cost consequences of the late acceptance. She's dealt with the cost consequences of late acceptance, and there was an argument before her which was not decided as to the form of order on the approval. And what in short was being suggested by the claimant was that the court could come up with a form of order which didn't in the order refer to the damages, and therefore wouldn't risk coming within 4414. And as we see over the page, it was made very clear by the defendant that if the claimant tried to do that, that would be said to be contrary to usual practice on approvals, where such orders normally do refer to the damages, and the defendant would argue that that was an abuse because it was an attempt to avoid the effect of CPR 4414. And so these are live issues, these are real arguments with a potentially real effect, where form is taking precedence over reality.
I mean, this is an illustration of a point which I think I put to Mr. Hutton, which is that one should construe, or perhaps one should construe His Honour Judge Sephton's order, certainly paragraph 2 of it, in light of the provision of the CPR that he thought obliged him to say something.
Indeed, sir.
The actual form in which he said it actually shouldn't make a massive difference. The real question is, what is he doing under the rules, which will either have a result or won't have a result, which would sort of take things away from this type of argument. If
Indeed,
you
so.
look at what the rules require and then construe the order accordingly.
Lord, yes, and that's at the heart of both the narrow and the wider point here. Yeah. Because our fundamental concern is that if Mr. Hutton, the argument that underpins Mr. Hutton's case here is correct, which is that if you have an order of the court which within that order makes reference somewhere to the amount of damages or the amount of the payment that the claimant is to recover, that brings you within CPR 4414, then that not only raises problems with the periodical payments and the provisional damages, but it raises arguments with the normal practice in relation to approval of cases involving children and protected parties.
Put another way, it raises pitfalls for the unwary draftsman, which shouldn't be there.
Indeed, so these should not be, I've cited it in our submissions, but these should not be tripwires for the unwary. This should not be paying the mortgages of the professional negligence practitioners. These should be clear rules which can be clearly applied. So, my Lord, against that introduction and just using the relatively few remaining minutes...
Well, we've asked you questions, so I'm not going to police the Master of the Rolls 15 minutes to the minute.
Lord, I'm grateful, but I hope not to take too much longer anyway, because we say, in terms of the narrow point, we say there are two short answers to it. And by the narrow point, I mean the CPR 36229 point. In other words, putting aside the specific facts of this case and the precise wording used in his order by the judge here, but does the exercise under 36229, if it is carried out, and acknowledging the point that it may not be necessary to be carried out, but if it is carried out, does that create an order for damages under CPR 4414? And the first short answer to that is we say, just to compare, which the court already has done, the language of 36229 to 4414.1. Because we say that if you look at it, all that is required under 36229, if it is engaged and if that exercise is being conducted, is to make a direction as to whether the amount of the offer should be reduced, and then to go to 3611.3 and give permission or not to accept the offer. And in short, we say the judge was absolutely correct at paragraph 13 of his judgment when he concluded that none of that involved making an order for damages. And really, we say it is that short. It is a simple comparison of the two sets of words. The exercises are not the same. The first simply goes to the adjustment, if necessary, of the amount of the offer, and then any giving of permission to accept it. And what follows from that should not then turn on precisely how the judge records what he's done in his order, but the substance of what he is doing. The second short answer to the narrow point, we say, is the extracts that this court has been taken to and has already considered from Adelekan. And I won't delay on that at all, because the court's been taken to them and has considered them and is more than able to form a view as to whether or not those form binding ratio. We would say that the court in that case does appear to reach a judgment as to the effect of Cartwright, which draws the dividing line down between the line of settlement on the one hand and matters which go to trial and substantive judgment on damages on the other. But it's a matter for the court. But if that is correct, that of course is a short answer both to the narrow and the wider point. Moving then to the wider point, and this is the basket of cases. So,
sorry, when you say the wider point, so this is...
This is the potential effect, if Mr. Hutton is correct, on other cases. So the periodical payment cases, the apportionment cases,
so the paragraph 103 point.
Paragraph 103 point,
yeah.
for shorthand. So the starting proposition here, of course, is that under the present rules, the defendants accept that ordinary compromises and Part 36 acceptances don't bring claimants within scope of CPR 4414, nor do they do so usually even if those acceptances are out of time. But the defendant says some circumstances where the case is resolved by an agreement to pay, by a settlement, do so. And we have the list at paragraph 103. And if it's correct, and I'm only going to pick one example out of that list, I'm not going to take the court through all of them. We support the submissions made by Mr. Hogan for the claimant here, that this leads to a plain absurdity. It leads to a situation, to use the expression that's been used by the court today, which is bonkers. The one example I'm going to highlight is that of provisional damages, just because it's an apposite example to illustrate the absurdity. If Mr. Hutton's argument is correct, the fact that if a settlement is made which involves the payment or the potential payment in due course of provisional damages, then the court must make an order providing for provisional damages, Mr. Hutton says has the effect then of bringing all of the claimant's damages, not just the provisional damages, the potential provisional damages, but all of the claimant's damages within the scope of CPR 4414 for the purposes of set-off. So you end up with this peculiar position where for claimants you have a choice. You can bring your claim and settle it without provisional damages and you're completely outside CPR 4414 if you settle it, even if you settle it out of time. Or you can bring your claim with a claim for provisional damages and a settlement involving provisional damages, and even if you settle it in time, the fact that you have a settlement which provides for the potential of further damages to be paid if a future event occurs, because of course that's what provisional damages are dealing with. It's not a further amount of damages now, it's the potential for a relatively unlikely event to incur in the future where you may get future damages. So that potential for a sum of future damages if a future event occurs brings all of your damages within the scope of CPR 4414. Not the future damages, of course that couldn't really work, because otherwise then, if it was just the future damages that were said to be brought in, you'd end up with the defendant hanging around for years to wait to see if the provisional damages issue ever arose, and then pop up and say, aha, we've got a costs order. Mr. Hutton's argument has to be that brings all of the claimant's damages, even those that aren't actually even mentioned in the order for provisional damages, within the scope of CPR 4414.
So that would all be predicated on the happening of a future event which may or may not happen.
Indeed, and future damages which may or may not be paid. And we say that is just one example, perhaps the starkest example, but of the absurdity. But it also, of course, highlights the unfortunate consequences if Mr. Hutton is correct, which is that we all know that, for example, periodical payments are something which have been encouraged and which have become a common feature of personal injury practice over recent years. But you end up in a situation where those advising claimants have to consider the fact that if they seek periodical payments, even if the case settles and even if it settles in time, they potentially bring themselves in the scope of CPR 4414, whereas if they don't seek periodical payments, they keep themselves outside the scope of CPR 4414. And we simply say in relation to that, when we consider that, there can be no logical basis on which it can be said that there would have been a legislative intent for that to be the outcome. And so, my Lord,
is it an unfair question to ask what, take periodical payments as the example, what would be the effect of the new or the possible amendment to the rule, or is that you're welcome to decline that if that is appropriate?
Well, my Lord,
I don't want to be back here in 18 months' time arguing about what is or is not an agreement to pay.
Well, my Lord, I suspect there may be debate as to precisely what is meant by agreement to pay, but it,
Right,
it
well,
would,
it's an unfair question.
But my Lord, no, I'm willing to give at least a partial answer, if I may, which is it does appear that the inclusion of the words agreement to pay is an attempt to override the effect of Cartwright. In other words, to bring payments of damages to claimants within the scope of QOCS, and therefore that would appear,
I mean, my reading of it,
to cover all damages.
Yeah, my reading of it entirely without anything else. Just when I read it, I thought, oh well, the reference to costs was to deal with Adelekan, and the reference to agreements to pay was to deal with Cartwright, as confirmed by Adelekan.
My Lord, that is without prejudice to any arguments I may find myself having in due course
I
in this
understand that,
court or elsewhere.
and that's duly noted.
That was my reading of it for what that is worth. which is why I categorise the idea of it being a small amendment as perhaps a little surprising.
What about acceptance of a Part 36 offer? If Mr Hogan's right, that's not caught by the words agreements to pay.
Well, my lord, I understand his argument in relation to that, and I don't disagree with it, but equally I can see there's a lot of scope for argument about that point.
So, I mean, if my lord is right and they've identified 2 cases over which they need to put a sticking plaster, they've left Part 36 acceptances outside the new rule because they don't give rise to quotes and agreement because it's a freestanding.
Lord, I think at that point I may exercise my right to take the fifth if that's appropriate at that stage, because I am aware of those who I represent and that they have interests in the question of this potential amendment.
Yeah,
so,
okay.
But my lord, I can see the point that prima facie it would appear that those words are or may be intended to overturn the effect of Cartwright, which would, if that were correct, mean that settlements, whether they be by way of Part 36 or otherwise, would be within the compass of CPR 4414.
Well, although it's wholly outside the scope of this appeal, obviously one would hope that given the importance of QOCS, one would hope that any amendment to any of the rules relating to QOCS was based on consideration of all the potential ramifications.
Indeed, so.
I think that's all I can say about that, but I would say that.
My lord, and just in passing, of course, one of those is the temporal effect of any amendment, in the sense that, of course, the presumption against retrospectivity does not normally apply to procedural rule amendments. So, unless it was carefully drafted, you could end up in the bizarre position, for example, of the third defendant in Cartwright popping up and saying, well, we couldn't enforce under the rules as they were now, but now the rules have changed, we in fact can. I'm sure those drafting the rules will be alive to those points. And
I'm sure. It's the wider point, and as I say, the introduction of those 3 words, which I couldn't find had been heralded.
Lord, yes, and I think that is widely felt that the implication had not been appreciated of those words.
Okay, well, I can't comment about that, but that was, yeah.
But my lord, coming back to the point,
yes.
I'm focusing on the present rules because
yes.
they may still be with us. They may not change,
yeah.
and if they do change, we don't know quite how they will change. And our fundamental point is that there is no logical basis to support the construction that the defendant advances. It is, if correct, an outcome which would lead to absurdities of the type that have been identified, and to the creation of a set of tripwires based on form, not principle, which would only be of benefit, frankly, to cost counsel and professional negligence lawyers, all of whom are admirable people, but that's not the purpose of the rules.
Yeah.
So, Lord, I'm grateful for the time, but unless your lordships have any questions, we would simply ask that the court does engage, not merely with the narrow point of the effect of 36229, but with what I'll describe as the paragraph 103 issues.
Thank you very much, Mr. Manley. Yes, Mr. Hutton, anything in response?
My lord, just a few points. To pick up the point that my learned friend was discussing at the end, and the matter that Mr. Hogan has also raised about the absurdity. What we would say in relation to that is, if the dividing line is between settlements and trials, what is the logic of that dividing line? Why would Parliament have intended, and the Rules Committee have intended, to distinguish those 2 cases and to say, in cases which go to trial, you can set off your costs, but in cases which settle, you can't? There is no logic or policy reason for that. Indeed, it's a perverse incentive for defendants, because the defendant might think, we might as well take this to trial because I'm not going to get my cost back unless I take it to trial. So that we would suggest is not a happy outcome. And where you start from the position that we do, that there's nothing inherently unfair in claimants having to pay costs which they've all been ordered to pay as long as they've got the damages, then the outcome is not so absurd. The outcome is perfectly sensible. And certainly, so in
But
relation...
You say it's a disincentive for you to settle. Conversely, it's an incentive to the claimant to settle.
Yes, but it's got to take two to tango. Both parties have got to agree to settle. So if the defendant doesn't want to settle, the defendant doesn't settle. The defendant's got to make offers or accept offers. So they've got to make that decision.
But then you are at risk because you have offers made to you by a claimant to protect themselves against the cost consequences.
Well, absolutely. We do have risks, and those things would all be factored in. But one disincentive for accepting offers or for making offers might be, well, we won't get our costs back, and if the costs are significant, then that may be a factor in suggesting to the defendant, well, actually, let's take it to trial, which is a perverse incentive, because we're all supposed to be encouraged to settle. And this, if that dividing line is here, then defendants are not encouraged to settle by this. They're encouraged to take things to trial.
Oh, I see the point, yeah.
In relation to the issue of whether Adelekan and Cartwright are binding on this point, I mean, the issue was raised, obviously, the comments of Lord Justice Lewison on permission are his comments, and your lordships will make up their own minds having heard full argument. But Lord Justice Lewison did say that although it's true there are obiter dicta in both cases which support the judge's conclusion, it cannot be said that there is authority binding on this court which covers the precise set of facts that arises in this case. And we would say that that was so both in relation to Cartwright and in relation to the Hoe case, and that there is a danger, we would submit, in interpreting Lord Briggs's words as though they were a statute, rather than interpreting them in the context of the factual circumstances of the case in which he was dealing with, and the case that he was commenting on, namely Cartwright. And those comments have to be seen in that context, we would suggest, and not in any wider context, because there's no suggestion that any of these points about these cases was ever put to the Supreme Court. It was never argued. There's no suggestion that it was. So we would submit that it would be wrong to then interpret those words for factual scenarios that were never even in play and never discussed. In relation to the disability argument and the paragraph 103 point, and particularly Lord Justice Stuart-Smith's comment that these are the claimants with the most need for protection, what we would say is that these aren't all necessarily the highest value claims, although some of them will be. But if they are a high value claim, then having a costs order against you is going to be less damaging than that you have to pay out of your damages. So if you have an interlocutory costs order for £2,000 and your case is worth 10 million, it's not really going to impact on you as if your case is worth £2,000.
Don't accept that, no. Because if you recover £10 million, it's because you need the £10 million.
Well,
it may be a smaller proportion, but if you knock out £100,000 from a £10 million claim, that can be very damaging.
It can, but if your claim is £5,000 and you lost £4,000 on an interlocutory costs argument, then you're
not so badly off in the first place.
Well, that's true. I entirely accept that. But these are cases where if they are the more disabled, they're going to be of higher value, and they're not all high value cases. Provisional damages, as my lord said in relation to epilepsy, you can have cases where there's a head injury where the damages aren't that large, but there is a small risk, say 2% or 5% of epilepsy or something of that sort. You're not going to get much damages from that, but you know there's a small chance that there will be a serious deterioration. So that's not necessarily a high value case. In relation to approval hearings, it's any children, so that doesn't necessarily have to be a high value case. It could be the £2,000 damaged finger sort of case. In relation to periodical payments, I accept that those will be generally high value cases, but in relation to apportionment cases, in fatal cases, those won't necessarily be high value cases, and those aren't claimants that are disabled in terms of using the disabled epithet. So it doesn't follow that all the most serious cases will be caught. I accept that there are all cases which have some sort of complication, which is why the court requires an order. I accept that, but it doesn't necessarily mean that the most serious or the most disabled. And we include in our category cases which simply settle, and there's an order saying by consent it is ordered that judgment for the claimant in the sum of £100,000. That is an order for damages. That could apply to anyone. That's not a disabled person or anything in any category. If there's a settlement in which the court makes an order by consent for damages, that is an order for damages within CPR 4414. As I say, in relation to that, an order of the court is an order of the court, and the parties want an order of the court because they can enforce it. So just by the fact that it's by consent doesn't make any difference to the fact that it's still an order of the court. And that's all that has to be so in 4414. In relation to the Human Rights Act point, where we say, and I don't wish to, obviously I haven't got long, I don't wish to labour the point, but where we say that this has really gone wrong is that you don't have a possession within Article 1 of the first protocol, A1P1, unless you have a legitimate expectation of having that possession. So, for instance, can I take the court just very briefly to the decision of Frost and Times newspapers, which is in the authorities bundle at tab 30, which I'll give you the page reference number.
Flood.
Is flood, sorry.
Wrong,
flood and
wrong meteorological disaster.
Yes, I'm sorry. Absolutely. So flood was a case in the Supreme Court in 2015, and it was one of those
Could
ones.
you give me the page number?
Sorry, oh, sorry, it is. I haven't given you it. It's 567.
Thank you.
And it was a case, a series of libel cases, 3 separate libel cases. Actually, Frost was one of them. Frost, Miller, and Flood.
I see.
So yeah, that's where I got the Frost from.
Yeah. And you're now going to tell me that Frost is the key one.
Absolutely. And essentially, this was related to the recoverability of success fees and ATE premiums post the 1999 Act, and the newspapers complained that this was an infringement of their Article 10 rights because it had a chilling effect on writing articles, because they would then have to pay double the costs and ATE premiums. The case went to the House of Lords, called Campbell, where the House of Lords said no, there was the scheme was lawful. They then took it to the European Court, which says the scheme was unlawful to allow them. And then these cases arose after that, in which the defendant news organisations sought to say that the European Court decision should be imposed, and all these claimants who had succeeded in their claims should not be able to recover success fees and ATE premiums, because it would be contrary to the defendant's Article 10 rights. And at paragraph 45 on page 584, it said, on behalf of Mr. Miller, that's one of the claimants, it is argued that there is a good reason to depart from the country, that if we were to order ANL would not have to pay the success fee or the ATE premium for which Mr. Miller is liable, we would be raking a plain injustice on him. So that's the claimant. He embarked on this claim against ANL, and in particular he incurred liabilities to his lawyers for any success fee and to his insurer for the ATE premium, in the expectation that if the claim succeeded and he obtained an order for costs, ANL would be liable to reimburse not only the base cost but also the success fee and the ATE premium. At the time he did so in 2009, to the knowledge of ANL, and at the time that expectation not only reflected the law according to relevant legislation, i.e. the 1999 Act and consequential provisions of the CPR, but also when that law had been held by the House of Lords in Campbell to be consistent with the Convention, in particular Article 10. In this connection, I consider that it would not simply be a plain injustice on Mr. Miller to deprive him of the ability to recover the success fee and ATE premium. It would, in my view, infringe his rights under A1P1. And then he has, at the top of the next page, in a reference to the case called Lawrence on fourth line down, must have had a legitimate expectation that the system would apply and be upheld. And then at 47, support for the notion that Mr. Miller can rely on A1P1 in the instant circumstances appears to me to be found in the discussion on A1P1 in Seymour and Emerson Human Rights Practice 15.00010, which includes the proposition where, in reliance on a legal act, an individual incurs financial obligations, he may have a legitimate expectation that that legal act will not be retrospectively invalidated to his detriment. Reference is to various cases, some of which are in the bundle. Pine Valley, Pressos is in the bundle, and Stretch is in the bundle, are all cases where the applicant's disappointed legitimate expectation of a legal right was held to justify his A1P1 claim. In Pine Valley, assumed validity of a planning permission, and Stretch assumed validity of a contractual option. The basis of the claim was not as strong as here, where it is based on primary legislation whose validity was approved by the law lords. And on the other hand, both relate to loss of land-related rights rather than a money claim. Pressos provides a closer analogy for present purposes, as it involved retrospective amendment of legislation which deprived the applicant of an accrued statutorily based claim for damages. Now, so what the claimant has to show in order to say that they have an A1P1 right of possession is that they had a legitimate expectation that they would receive it. And there's no evidence that the claimant had a legitimate expectation that costs were not going to be set off against their costs.
There's two different points there. This is
Yes.
talking about having your rights changed
Yes,
as well once you've got your case up and running.
yes, because you have a legitimate
Vindicate your
expectation
rights.
on one basis and then they change the basis.
So legitimate expectation is spoken about in those terms, isn't
Yes.
it, in relation to retrospective legislation?
Yes.
I mean, there's no retrospective legislation in this case. But
No, well, that's our point, really, is that there is no legitimate expectation. In order for the claimant to succeed, she would have to show that she had a legitimate expectation that these costs would not be set off against her. That's effectively what she said, and that if you then ruled that these costs were set off against her, that would be a disappointed legitimate expectation, which sounds in A1.
you're saying, in effect, we'd simply be ruling on what the rules have always said for the purposes of this claim.
Yeah, absolutely.
If you bring your claim to vindicate your rights,
Yes.
the rules mean what they say they mean, even if they aren't declared to
Yes.
mean that until some later stage.
That's absolutely
What can't
right.
happen is that somebody moves the goalpost once you've kicked off.
Exactly, and that's what we say couldn't happen here. Whatever you rule on this, you're not changing the goalposts, and so the case doesn't get off the ground on A1P1 because there isn't a possession in terms of I am entitled to those damages and no one can take them away or set them off. There's no possession that the claimant has because she doesn't have a legitimate expectation to that extent. And it's a necessary step from
Well,
A1.
she could have a possession. It's just that you can't, by legislation, frustrate her legitimate expectation
Yes,
based upon her possession.
yes, that's
Is that
right.
what you're saying?
No. So in this example, the claimant incurred a load of costs. Instructed lawyers took a claim
Yeah.
on the basis that they would always be able to get the success fee and ATE back if they won. And then the defendants argued, actually, you shouldn't be able to do that. And that would be an infringement of her A1P1 right because she had a legitimate expectation. If I win, I will be entitled to recover my success fee and my ATE premium from the defendant. And
Yeah, I'm only questioning whether you need to go so far as to say that she hasn't got a possession.
well, she hasn't. There is no A1P1 right that's been infringed here. If you were to order that costs should be set off, that's not an infringement of her A1P1
I
rights.
think that's a different point from saying she doesn't have a possession in the first place.
Right, well, she doesn't have a legitimate expectation of that the legal act will not be retrospectively invalidated to her detriment. She doesn't. That legitimate expectation doesn't, or a legitimate expectation in other cases of obtaining effective enjoyment of the property right.
That's because if you're right, nothing's changed.
Yes.
And I think that's the way the point
Yes,
checks out.
absolutely.
So ultimately, it may actually not matter, depending on what the interpretation is. But anyway, you say, if you're right as to the interpretation, this doesn't save them, as it were.
Yes, and it's not like a retrospective change as was suggested here. And in terms of what she expected to get back, of course, during most of the action, there was a right to set off of costs against costs by virtue of the Howe decision, which was made in July 2017, which was then overturned by Howe in October 2021. But throughout that period, any legitimate expectation could be that costs could be set off against costs. And indeed here, the claimant has costs up until the end of the 21-day period, and we have costs thereafter. So those could have been set off, and in hers and her solicitors' minds, that was the expectation, that there would have been set off of costs against costs. So she doesn't get over the hurdle of showing that I had a legitimate expectation that there would be no set off in this case, and you've now changed it retrospectively.
I confess I'd forgotten the complication of Howe.
Yes, so Howe overruled Howe.
Yeah.
And a Court of Appeal in Howe said, well, it's Court of Appeal in Howe said we don't like Howe, and that's why it got to the Supreme Court, and the Supreme Court said the Court of Appeal in Howe were right, Howe was wrongly decided.
That reminds me, don't worry about it now, but
Yeah.
if you could send to my clerk the link to Howe in the Court of Appeal.
Certainly.
Because Lord Briggs and Lady Rose set out in summary form what Lord Justice Newey and Lord Justice Mayle said.
Yes.
And for myself, I'd be quite interested to read that, and I didn't have time to chase them down before the hearing. So if you could just send the link, that would be good.
We will certainly do that.
Thank you.
Yes, certainly. And there's just one other point which arose at the... Oh, sorry. Yeah. So, can I just... Yes. And our point about this being run on appeal for the first time, and I'm not hidebound or in any difficulties with dealing with this. I don't wish to say that. Is that if she wanted to provide evidence of her legitimate expectation as to what she expected, I suspect she'd have problems given the reasons that I've said, namely, set-off was allowed at least against her costs. She would have to produce evidence for that, and she hasn't produced any evidence, and she can't do so on appeal. So that's we say there are insuperable difficulties in terms of this argument at this stage. The other point I just wanted to pick up on, and I think it's the last, is I'm afraid to go back to 3622 and how the recovery of benefit works, because I'm afraid we don't agree with everything that Mr. Hogan said about how the scheme works. And the reason we say that the essence of what Mr. Hogan was saying was that ultimately what the court says about the recoverable benefits is not to the point. We can simply appeal it under Section 11 of the Act, and that will end up at the first tier tribunal. We don't accept that's right, because, and it is complicated, unfortunately. If you look at 3622 and subparagraph 1, there is... Sorry, it's 1313 of the white book. Sorry, I'm skipping.
When we revamped Part 36, my complaint was far too long.
Yes.
This shouldn't be in the rules. This is the court trying to be too helpful. No question about that.
So it's
Right, last time
1313.
in 3622,
Yes.
I think.
So there is a distinction in 3622 in C and D between a recoverable amount and recoverable benefits and deductible amounts. And the recoverable amounts are defined in the 1997 Act. And the deductible amounts are not a term of art in the 1997 Act. They're a term of art in this rule alone. And essentially what it means is, I need to just take you briefly to the Act, which we have at tab 2, which is page 6. The distinction can be illustrated by this point. I pointed out that in relation to the Part 36 offer that was made initially, the defendant did not offer the whole of the PIP mobility element that had been paid by the CRU, because the claimant had only claimed £42 of it. So we only allowed £42 against that. Now that is an illustration of the deductible amount. That is how much has to be deducted. But under the legislation, we as the defendant have to pay to the Secretary of State the full £5,000 for the PIPM, the mobility element of the PIP payment. And so the deductible amount is what the court determines has to be deducted from the claimant's damages, but we have to pay, as the defendant, we have to pay the recoverable amount, which may in certain circumstances be more. So if one looks at it in the legislation, section 6 of the legislation requires page 17 of the authorities bundle. Section 6.1 says liability to pay the Secretary of State amount of benefits. 1. A person who makes a compensation payment in any case is liable to pay to the Secretary of State an amount equal to the total amount of the recoverable benefits. So that's all the recoverable benefits. And the contrast is to section 8, which is page 20, which
so section 6.1, that's you, is it? A person who makes a compensation payment.
Yeah, my client pays that.
Defendant pays compensation payment.
Yeah.
Yeah.
That defendant has got to pay the total amount of the recoverable benefits. That is what is on the CRU certificate. But in relation to the claimant, section 8 deals with reduction of compensation payment, and section 8.1 says this section applies in a case where, in relation to any head of compensation listed under column 1 of schedule 2, any of the compensation payment is attributable to that head, and any recoverable benefit is shown against that head in column 2. So that's the different categories of benefit compared to, for instance, the loss of mobility, the PIP mobility element. So what section 8 is doing is how much you reduce it in terms of how much you pay to the claimant. And so in my example, which arises in this case, under section 8, we have to pay the £42.34 because she hasn't claimed more than that at the first at the outset in relation to the mobility element. But section 6 requires us to pay to the Secretary of State the full £5,000 mobility benefits that have been paid. And section 8 is dealing with reduction of the compensation payment, and that then brings in the table that you see that I've referred to, which we looked at earlier. That we looked at earlier, and the table then has as I've said, the named benefits and what it's attributable to. And section 15, which you don't have in here, but Mr. Hogan quite rightly mentioned it, says that the judge at the trial must attribute each element in this table against the benefits that have been paid. That is, in effect, doing the process of section 8, but doing it by a judge after trial. So under section 8, we're quite right to say you've only paid, Crew has only paid £42, you've only claimed £42.34, therefore that's all we have to pay you, but we have to pay Crew the remaining £5,000 because that's the benefits that have been paid to the claimant, and we have to pay them.
But I think you started off by saying you didn't agree about what he said about the mechanism of appeal and going to the tribunal.
So where we disagree is in section 11, which he raised, which is at page 28, he said that our remedy was here, appeals against certificates. But section 11 is an appeal against the certificate of a recoverable benefits. In other words, all the benefits that are paid. And we can appeal that, but that's appealing the £5,000 PIPM, not appealing the £42.34, because we have to pay the difference. So section 11 doesn't give us a remedy in relation to the claimant. That's nothing to do with the claimant. That's the recoverable benefits. The deductible benefits, which is the term of art used at 3622, is actually what you do under section 8 and then at trial at section 15, which is to work out in relation to each head of loss, how much benefits have been paid in relation to each head of loss. So insofar as the judges, in relation to the judge's role under 3622, the judge has to determine, we say, the deductible benefits. In other words, the judge has to, if it went to trial, the judge would look at the table and go through the table. And we say that table is clearly what is in play here in relation to deductible benefits. Because if you look at 3622(1)(d), deductible benefits means, deductible amount means, any benefits by the amount which the damages are to be reduced in accordance with section 8. Well, we've just looked at section 8 and schedule 2. We just looked at schedule 2. And we say it is significant, the amount of which damages are to be reduced. So what the judge is doing in the exercise at 3622(9) is going through section 8 and working out what the deductible benefits are, which directly affects the claimants because it's reducing from the claimant's figure how much of that amount actually goes to the claimant as opposed to goes to the compensation recovery unit. So that is a genuine exercise by the judge in relation to the deductible benefits, and it is reducing, in the words of 3622, it is reducing the damages that are payable, and therefore that's why we say that feeds into our argument on 22.9 that what the court is doing is making an order for damages and interest under 22.9. So there is a genuine exercise here by the judge. If it's disputed, it happened to have been agreed, but if it's disputed...
yes, so you say if it was here it's agreed.
Yes.
Here it was agreed. But had it not been agreed, then what would have happened?
So if it had not been agreed, then the judge should have then gone through section 8 and gone through the table at schedule 2
Where's
in the Act.
the power to do that?
Because the judge has got to direct
He doesn't have to direct. We've been over that.
Yes.
He may direct.
Yes.
And that's a very odd choice of language for a substantive calculation by a judge, which you're saying he had the power to do.
Yes.
Usually when you direct something, it's effectively you're bringing into play something that in this case has been agreed. That's the sort of language you would use.
Well, we've used various examples in my skeleton. I can go to it as to where direct is used in the CPR, and it's used in many different contexts. And sometimes,
I'm sure that's right. We're just looking at this one.
Yes. It effectively means orders. The two are pretty much the same. Now, why they've chosen direct and why they've chosen order sometimes may be significant, sometimes maybe not, but it means the same thing effectively. When a judge makes a direction...
So you say may direct gives the judge the power,
yes,
jurisdiction, to sit and calculate the amount of the deductibles, even where the parties are agreed?
Yes. No, well, if the parties are agreed, then it's like...
No, where the parties are agreed on
yes,
the
Gross.
the gross
amount.
Yeah, but not agreed on the deductible amounts, then we say that the judge, otherwise...
And how does that affect judgment in 14 days?
Well, because that determines, as you know, paragraph 2 of this order does, that determines what the sum is
No,
payable
I'm talking
to the
about the
claimant.
principle. Leave aside the particular order here.
Yes, but it determines what is due to the claimant, and so that then you can enforce that because, and we say you can enforce the order because it's the order which provides the figure that you enforce. So the 298,000.
Rules say. Anyway, we've been over that.
Yes, so the 298,000. I mean, otherwise we ask if it was the empty process which Mr. Hogan suggested is, what is this rule doing in the CPR? If the judge can't do anything...
I'm frequently asked about many of them.
Well, that may be so, but we say there must have been a purpose behind this, and the purpose is that the judge is carrying out a real exercise to work out what the deductible benefits are, and that is separate from the crew certificate. It's related to it, but it's separate because the defendant has to pay all the recoverable benefits, and not, and that may be beyond what the deductible benefits are. And so that you know, otherwise, this rule would genuinely be a waste of space. And I, notwithstanding your Lordship's comments, I would suggest that the court would be reluctant to assume that the Civil Procedure Rules Committee had enacted an entirely OTO's provision, which has been in the rules for a long time.
Well, I get that.
My Lord, that's no more 3622. You'll be grateful to know.
Thank you very much.
Thank you.
My Lord.
I want to make Richard anything. Yes, Mr. Hogan.
My Lords, I know it's...
I'm not going to stop you saying anything, but just bear in mind the time and that it would be right to allow Mr. Hutton to comment on anything you do say. So he has the last word.
It's a very short point.
Yeah.
I'm very conscious it's not tennis. At trial, a judge awards heads of loss and then he takes the benefits off.
Yes.
In the context of an application, you can't do it because it's a lump sum settlement. You just can't hypothecate deductible benefits against the 298,000.
You made that.
Forgive me.
I don't disagree with that, apart from in the instance where, for instance, more benefits have been paid in relation to mobility than have been claimed. Then the judge's job would be to say, well, actually, we think that benefit, the only £42.34 has been claimed, and therefore the deductible benefits are £42.34, not £5,000.
Okay. All right. Well, thank you all very much. We'll reserve our judgments. You'll get drafts in the usual way. That's to allow you to correct typographical errors. It's not to allow you to re-argue the points in the case, fascinating though they be. We will ask you to agree an order. If you can't, then we're happy with very short written submissions on any points in the order that you can't agree. When the draft is circulated, it's circulated solely for the purposes of this case, so therefore, as you know, any unauthorised leaking of the draft judgments will be, and currently is being regarded as a contempt of court, as I'm sure you're aware. So I can't promise when the drafts will be circulated, but we'll endeavour to do them as quickly as we can.
Thank you.
All right, thank you very much.
All right.